For years, estate planning was all about one question: will I owe estate taxes? But things have changed. And that's why today we're going to cover the new permanent estate taxes and what they mean for you, why many estate plans still don't reflect Secure Act changes, plus how modern estate planning is shifting from avoidance to flexibility and protection. Hi, I'm Molly Nelson here with Lauren Merkel and Charlie Bodenberg. Charlie is an attorney with Brick Gentry Law Firm, and Charlie practices primarily in the areas of estate planning and small business planning. And Lauren, you've known Charlie for a while now. He leads our Lunch and Learn presentations, and a lot of his estate planning knowledge he shares with us here at Merkel Retirement Planning.
Yeah, there's a lot of things that are really important when it comes time to select who you should use as an estate planning attorney. One of those things is the attorney should focus on estate planning. There's so many laws, so many changes to those laws, and when we're talking about something as important as your final wishes and what you've saved over the last 40 years, going where you want it to go, that's really important. And what we've heard a lot from the families and individuals who have used Charlie is that he listens. He listens to them, their concerns, their wishes, and then he's educationally based, which is why he teaches a lot of the Lunch and Learns. He wants to teach, he wants you to learn, and he wants to make sure that your wishes match up with the legal documents in your estate plan. Charlie fits the bill when it comes to all of that.
And that's a glowing endorsement, Charlie. There's one thing you have to mention before we roll. It's kind of a compliance thing.
As always, need to point out, this is not attorney advice, right? This is for informational purposes only. Happy to meet with you and establish an attorney-client relationship. You should definitely have that in order to make sure that you're getting the proper estate planning advice that you need.
Okay, let's get right into that information, because the estate tax, it's something sometimes people talk a lot about. It gets maybe a lot of publicity, Charlie, but with current legislation, it really doesn't impact a lot of people.
Yeah, so historically, the estate tax has been $1, $2 million, $5 million. Currently, we're sitting at $15 million per person, which means with a proper planning and a little bit of tax work on the back end, it's a $30 million exemption for a couple. Most of my clients don't have an estate tax problem. Further, Iowa got rid of the inheritance tax, which was based on who you would leave assets to. That fully sunsetted January 1 of 2025. So currently, in the state of Iowa, if you're a married couple, you can leave up to $30 million tax-free. Estate tax-free, inheritance tax-free. There's other types of taxes.
Right.
Or if you're a single individual, you can leave up to $15 million estate tax-free.
So it's not the estate taxes that people have to worry about, but there are some different things that go into the estate planning. And before we get to those, I do want to talk a little bit about terminology here, because we're talking estate planning. That's kind of the focus area that you use. But really, for Merkel Retirement Planning, it's legacy planning. Estate planning is one of the things underneath that legacy planning pillar.
Yeah, legacy planning to me is really, what do you want to have happen to your assets when you pass away? And then estate planning is all the legal applications to make sure that that is actually going to take place. The legacy planning is one of the pillars of our 6 pillars of our Retire Secure Roadmap. The Retire Secure Roadmap is your lifestyle plan, income tax, healthcare, investment, and then legacy pillar. All of that makes up the Retire Secure Roadmap. The legacy is the last pillar, but that does not mean it's the least important. It may be the least fun to talk about because not a lot of people like to talk about their death and what's going to happen afterwards, but it is really important because everybody has an estate. A lot of people think that estate plans are for the ultra wealthy. That's not true. Everybody has an estate. Everybody has an estate plan. The question is that plan yours, or is it the government that presides over all of us? Everybody has an estate plan. Let's make sure it's your plan and your wishes are fulfilled.
Okay, so let's talk about what it is. So we know it's not, for most people, that $15 million threshold. That's not something you have to worry about. But here's what they could worry about, or do maybe need a plan for, at least, Charlie: income taxes, beneficiary timing issues, control and protection when they're gone. That's the kind of stuff that can apply to almost everyone.
Absolutely. You know, almost universally, when we're talking to families, they either have a child who's not ready to inherit, or the mix of assets they're leaving behind is really important. Do they have a lot of retirement accounts? Do they have a lot of brokerage accounts? The way those are treated post-death, or even while you're alive and you're taking distributions, are very, very different. So, just because you don't have an estate tax problem doesn't mean you can't be unaware of the taxation that is involved in your estate, which feels like an attorney thing where I'm like just using the words in backwards. I kind of am, but it's really, really important, which is why you have to be able to have a good working relationship between your attorney and your other financial professionals, your CPA, your financial advisor, because everything is coordinated and impacted, and one of those not going in the correct direction can mess everything up.
Yeah, not long ago, I was asked a question. Somebody said, I'm inheriting inheriting some money, what kind of tax am I going to owe? Well, let's start with what kind of money. Who is the money coming from? Where is the money? Is it under an IRA, a Roth IRA, bank account? Is there going to be inheritance tax, estate tax? Is there going to be income tax? There's so many different taxes that can be associated with inheriting money. We need to start from the ground up to really identify what those consequences can be, and then what can you do about it.
Mm-hmm.
And one of the ways we can help the people that are watching learn is to talk about some of the mistakes that happen so that they don't make the same mistakes. And sometimes, Charlie, you see that people are kind of relying on plans that were written with rules that existed a long time ago.
Absolutely. You know, a great example of that, the Secure Act, when that passed, and it completely changed how we deal with retirement accounts post-death. It used to be that very frequently we would plan with what's called a pool trust or a family trust or a pot trust, all kind of the same thing, where, you know, when all the kids were under, say, the age of 18, the funds would be held in one trust. Well, the Secure Act fundamentally changed how those distributions happen, and by doing that, you may be cutting down on a 10-year distribution window down to a 5-year distribution window. That doesn't seem like maybe that big of a deal, but if you're leaving behind, say, $2 million in retirement accounts, instead of taking $20,000, it's really bad math, instead of taking $200,000 a year, you know, you could be taking $400,000 a year, and you could be absolutely pushing things into a much higher tax bracket, because trusts have what we refer to as compressed tax brackets, meaning you don't need to make nearly as much inside of a trust in order to pay the top income tax bracket. So it's very, very common that when you run into some of those trusts, they don't have the new language in them, which can cause some very, very large tax consequences.
And some of the things that Charlie's saying to me exemplify why it's really important that someone with the kind of knowledge a retirement planner has and the kind of knowledge that an attorney has communicate, and that happens a lot between both of you and the families and individuals we serve.
Yeah, it really does, which is also why it's important for your estate planning attorney and your retirement planner to have that working relationship. So Charlie can talk to me, have questions. I can talk to Charlie about questions on the different plans, and the individual, the family and individual that we serve can be involved in those conversations, or they cannot be involved depending upon their level of involvement as far as what they want. The important thing is that it gets done to the satisfaction of the client, to make sure that what they want to have happen will get done, and to make it as easy and accurate as possible.
And Charlie, I suspect this is one of the things you've seen over the years, and we talked about it a little before. Somebody sets up a will or something, maybe in their 20s or 30s, and then they get a little bit closer to their 60s, and they just assume that it's still going to work, and that's generally not the case.
Generally not the case. It's one of the reasons why, as Lauren mentioned, I take a very educational approach, and I try to diagram out what the different estate planning options are for each couple or single person, where they are, where they could be moving, and then sort of outline what some of those triggers are, because I'm not going to know when they've moved on. But a lot of times, whether it's probate avoidance, whether it's special needs beneficiary, whether it's your kids just growing and maturing, the needs that you have change, your plan needs to change with them.
You heard Charlie talk about probate. This is one of the areas where he gets a lot of questions at our Lunch and Learn presentations. We'll cover all you need to know next. Welcome back to Retiring Today. I'm Molly Nelson here with Lauren Merkel and Charlie Bottenberg. Charlie is an attorney with Brick Gentry Law Firm. It's time to talk about probate. Now, we only have a little under 8 minutes here, because I know you could talk about probate a long time, Charlie, and that's because people want to talk about probate. At our Lunch and Learn, that was the thing you got the most questions on recently when you talked to the families and individuals we serve. So we're going to get to some of those questions and some strategies, but first, let's just define what probate is.
Absolutely. So probate is the legal process in the state of Iowa where your assets are transferred from you after you pass away to whomever your beneficiaries are. That can be something called your heirs at law. Heirs at law mean you do not have an estate plan, or it can be something called your devisees, your beneficiaries, if you do have a will-based estate plan. The number one question I get is, what is subject to probate? There's a lot of misconceptions out there. The two really easy ways to know if you're going to end up in probate: do you own real estate by yourself, meaning you do not have what's called a joint tenant? And two, do you have an asset that is worth $50,000 or more that doesn't automatically transfer? Could be an IRA, could be a life insurance, could be a bank account. All three of those are reasons I've had to open probate in the last 2 years. Somebody doesn't have a beneficiary in an IRA or a bank account or a stock account, or only one spouse is on the house deed. That will also cause probate. So if you have triggered probate by having real estate or an asset worth $50,000 or more that doesn't transfer, all of your assets, what is called your gross taxable estate, are then subject to probate, meaning the assets that you have, say, beneficiaries on will still go to that beneficiary, but we must still account for them on the inventory. And oftentimes then sometimes court costs and definitely attorney's fees will trigger based on those numbers.
Okay, and generally speaking, it can be a good thing and a bad thing, but it's something the families and individuals we serve sometimes want to avoid.
They want to avoid it for the costs. Also, people's privacy is important, and things that go through probate are offer public notices. Things that don't go through probate typically are more of a private transaction. That's important to some people. But there's so many misconceptions around probate. First, what is it? How do I avoid it if it's something I don't want to go through? And one of the things that does lead to some of the misconceptions is it's very much determined by state law. So somebody might have an uncle in Nebraska or New York, and they're talking about what they're trying to do from an estate planning standpoint, and it is different than what it could be different than what Iowa law has.
And it generally is. I'm licensed in 2 states, Minnesota and Iowa, and the probate process, the probate rules they're just very different. The things you can do in Minnesota that you can't do in Iowa, there's a lot. We don't have time for that because we're not standing in Minnesota right now, so we're not worried about it. But yeah, every state has their own probate laws. In Iowa, we don't match a lot of the other ones.
All right, so one quick question that we get all the time. They establish their estate plan in Iowa,
sure,
but then they moved to Florida.
It's okay.
So what do they need to do at that point?
Yeah, so you obviously would want to talk to a Florida attorney to make sure that whatever the plan was in Iowa still complies with Florida law. But generally speaking, trust-based plans are by nature more portable because Iowa is a signer on a version of the Uniform Trust Code, which means we're a lot more compliant or equal with the other states. And then there's also usually something called a foreign will statute in almost every state that I'm aware of, where a will that was valid in the state you signed it is valid wherever you are.
Okay. Another one is most people who understand the notion of probate, their goal is to avoid probate. But in some cases, probate could actually be a beneficial thing.
Sometimes it can, especially when you have difficult beneficiaries or family members who don't get along, or strange assets that maybe just require court supervision. Or we don't entirely trust the kids to deal well with each other. And sometimes you just need a moderator. In that case, is the judge. You can get around a lot of that with a proper trust plan by naming a third-party trustee, whether it's a bank, whether it's a financial planner, although you guys normally say no, whether it's a relative who's not, one of the kids, maybe an aunt or an uncle or a cousin. But it does require a little bit more planning for sure.
I remember at the Lunch and Learn a question about IRAs and probate and then beneficiaries. Do you recall that question? And
not exactly.
There were a number of them.
Yeah,
but I've probably had that question close to 100,000 times in my career at this point. That's an exaggeration.
So you're
may
ready.
Not be. People always want to know, well, if I have a direct beneficiary on my IRA, that's not includable in probate, right? And the answer to that is kind of. So if I name my wife as the beneficiary of my retirement account, and she is, and I pass away, that retirement account is going to pass to my wife. However, if I have real estate or an asset worth $50,000 that doesn't automatically transfer, which then triggers probate, we still have to account for that asset on the probate inventory. Most of the fees, excluding court costs, are still going to apply for the full value. So if I have a $1.5 million IRA, potentially up to $60,000 in fees can still attach to that. I say potentially because you can always negotiate with an attorney, you can always negotiate with an executor. There's always some pieces in there, but they are very much includable in the estate. The only asset in our state that is not includable for the attorney and the executor or administrator fee calculation is life insurance with a direct beneficiary. So if I have a life insurance policy and it names my trust or my testamentary trust inside of a will as the beneficiary, that then skips both court costs and all of the other probate fees. But everything else is fair game.
And that's a bad thing, right? So most people would want to avoid some $60,000 for an IRA that they feel like, hey, I did the planning. I put the beneficiary down. It's up to date. It's who I want it to be on there. So to avoid that, you do what then?
So generally speaking, to avoid that, we take any asset, real estate, that would trigger probate, or something that's worth $50,000 that doesn't automatically transfer, and we make sure it's no longer titled in the name of that person. So generally speaking, that's a revocable trust. Sometimes it's an irrevocable trust. Again, need to talk to an attorney with your specific situation in mind to find out, do you need revocable? Do you need irrevocable? What type? There's a whole set of trusts that are all very, very different. But if you take your house, which is normally the asset that triggers it, you put that into your name as trustee of the trust, you individually no longer own that. Your trust owns that. You are still in control of it in your fiduciary capacity as trustee. Depending on the type of trust, you can probably still pull it out if it's a revocable trust. But when you pass away, we get to just appoint whoever you have named as your successor trustee. We don't need the court process. We don't need a judge to sign off on an order. If we don't need any of that, we don't have to go to probate. If we don't have to go to probate, that $1.5 million IRA doesn't get sucked. You can tell I've done this a couple times. Doesn't get sucked in. We don't have all those extra fees that are associated with it. Almost universally, trust settlement is going to be faster. It's almost universally going to be less expensive. It is for sure going to be more private. And generally speaking, it's going to be significantly faster. I said faster earlier, generally significantly faster. A lot of times we can get it done in 6-7 months versus a lot of probates are taking 12, 18, 24 months sometimes to get through the process because there's just a lot of steps you have to do. And a lot of the waiting game is out of our hands. A lot of the waiting game is you're waiting on the Iowa Department of Revenue, who does a great job, but they're understaffed to be able to pull something back. Or we're waiting on some asset to sell. If your house doesn't sell for 18 months, it just takes a long time to get through.
Coming up, we'll talk about the biggest shift in estate planning today. Welcome back to Retiring Today. I'm Molly Nelson here with Charlie Bottenberg and Lauren Merkel, and we're talking about the shift in estate planning. You know, maybe years ago it was more about avoidance, but it's more about flexibility and protection, and that is similar to what setting up a customized retirement plan can offer people as well.
Yeah, the key tenets of your estate plan are the same key tenets of the other pillars of your retirement plan. When it comes to your lifestyle plan, you want control over your day-to-day, your month-to-month. You want flexibility because life does change. When it comes to your income plan, you want control and flexibility. Your tax plan, your healthcare plan, all of those pillars, you want control and flexibility. It's no different than when it comes to your estate plan. The thing is, though, it doesn't happen by accident. You have to be really intentional and put that plan into place to make sure you get the control and flexibility that you need.
That's exactly what we do in estate plan. Flexibility for most of my families is king because we don't know what those tax laws are going to be when you pass away. So we want the plan to be flexible. We want it to be functional today with all of the bells and whistles it needs, but if the estate tax comes way down or the estate tax goes way up, we don't want to lock anybody in. A lot of the pre-2012 plans we see, before we had a concept called portability, that's when you got to use your deceased spouse's unused exemption, artificially segregate assets, and most of my clients don't need that anymore. I'm a huge fan of saying, you're gonna have to pay some tax. I know, we don't wanna do it. There's going to be some tax involved, but you have a much greater choice today than you used to about which one of those taxes you're gonna pay, and oftentimes we're just trying to limit, get it down as low as we can.
Yeah, so in practice, really what is a good way to go about it is because you're right, you're gonna pay some tax, it's just a matter of what tax. But you want to be able to choose. And the way to be able to choose intelligently is let's have plan A. If you execute plan A, here's the type of tax you're going to pay. Here's how much tax you would pay versus plan B. Here's the type of tax you would pay. Here's how much tax you would pay. Now you choose. And you get to choose knowing all of the information. And that's really the key to providing confidence to people making these decisions because these decisions are big decisions and they're complex, but having the information in writing in front of you can really go a long way to help with that.
Absolutely. And if we plan correctly, you don't have to make that decision today. You can set it up so that the decision is made when we lose either one or both of the spouses and pick which one of those taxations is going to be the better environment.
Well, I was talking about updating. I was thinking about updating plans, that's a paramount thing to do. You don't just set it once and then forget about it. You update it, and you still see some plans that haven't been updated since the Secure Act. Why is that problematic?
Well, it's problematic because I've been an attorney for coming up on 14 years, and roughly every 3 to 3.5 years, they completely change how all this works, right? So if your plan is more than, say, 2-3 years old, in this particular case, more like 5 years old, because it's been a little bit on these laws, chances are you've got one of those family trusts or those pot trusts inside of your trust taking care of things. And all of a sudden, we're going to end up, like we mentioned earlier, with significantly higher income tax because your time horizon is not going to be the full 10 years. You're only going to get 5. So we got to make sure that that matches. And then on top of that, you as a client need to make a choice. Am I trying to protect my beneficiary from themselves? Or am I trying to lower my beneficiary's taxation scheme? Those two things cut in opposite direction. I refer to that as the seesaw. You want lower taxes? Well, they're going to have more control. You want more control? They're going to have higher taxes. But you as the client need to make that choice, and you need to work with a competent estate planning attorney who understands that and can explain it to you. And there's dozens of us, hundreds of us probably in central Iowa. You just got to make sure you have one who does this day in and day out so they understand those differences and can make your documents function accordingly.
Charlie, sometimes talking with a professional for the first time can be rather intimidating, especially about topics that most people don't know a whole lot about.
Sure.
What's it look like to you? If somebody was to call you or email you, what does the first step look like for you as far as engaging with somebody?
Yeah, absolutely. So our process that we try to follow, and I use the word try on purpose because, sometimes I get involved and that messes everything up. I have amazing staff. We get the client scheduled for when they're going to come in. We send over some pre-work, explain that it's comprehensive, which in attorney terms means it's overdone. Why? Because I have 18-year-olds who are just starting out, and I have 106-year-old farm widows, and I have everything in between, which means if I hand you some pre-work, chances are something in there is not going to apply to you. But it has some questions, right? What are you worried about? What are your assets? Who are your beneficiaries? Do you have any beneficiaries with special needs, right? And the number one thing I like to say, you can't lie to your attorney, right? We cannot plan around something we don't know about. At that point in time, we sit down. My process is to walk people through what all their options are. Again, generally speaking, having done this for a bit, when I sit down with somebody and I already have their assets in front of me and I already know what their age is roughly, and I know what their beneficiaries are, I have a pretty good idea which plan they're going to want. But I get shocked all the time. And it's really important to me, specifically, that we get you into the plan that you want. I have lots of clients who pick a plan that I think is the wrong plan for them. But at the end of the day, it's their plan, right? So we walk them through it. We talk about all that. We talk about, their pressure points, what's important to them, what are they concerned about, any specific, items that are related to them. Are they going to have some complex inheritances? Do they have some complex farm in the background, right? That we got to make sure follows the family line, or grandma's going to come up with the Griswold cast iron skillet and hit them upside the head, right? If that's the case, I want to know that because we can plan for all of that, right? We then draft up all the documents. We sit down. We make them as intelligent as humanly possible, intelligible as humanly possible, excuse me. I am still an attorney. There are still a lot of big words in there. There's some Latin phrases. There's only so much I can do. But my goal is when somebody walks out, they understand how their plan functions, and equally important, they know what their next steps are, because we got to make sure things are retitled. We got to make sure that beneficiaries are reset. And if they give me information about their financial planner or their banker, I'm happy to send those instructions over for them. And as Lauren mentioned, have that conversation. That's actually how Lauren and I met in December of 2019. I called him to say, hey, we have a client, a mutual client. This is what I would like to see on these things. Do you have any comments or criticisms of that? I'd love to hear it. And we had a really good conversation. We ended up having coffee, and the rest is history. So at the end of the day, it's all about making sure that we're getting as much information, much education to the client as possible in a digestible fashion, because obviously we talk about this all day, every day. It's really complex. But then we got to make sure that you also understands what those next steps are on the back end, because the best plan in the world doesn't function if it's not properly funded or it's not properly executed.
If you'd like to get a hold of Charlie, here's all the information you need. It's Charlie's phone number. It's Charlie's email address. That's charlie.vattenberg@brickgentrylaw.com. I want to tell you about one more resource that we have for you. It's our Retire Your Way Toolkit. You can download yours now at retireyourwaytoolkit.com. Lauren, there are 5 guides there, and they cover everything from Social Security to longevity. There's a lot of estate planning information in there. It's jam-packed with information for people.
It's the information that you really need to help guide you through this important transition in your life. These are decisions that you have to make that you've never had to make before. And more information that you have, more digestible information that you have to help you with these decisions, it's going to give you a number of things. It's going to give you confidence, it's going to give you clarity, and it's going to give you comfort. And it's complementary, which could be the best part.
Yeah, here it is again. It's the Retire Your Way Toolkit. There are 5 guides in there. We didn't talk about Social Security today. We focused on estate planning. It's inside that guide. Longevity. There's also an income checklist in there and a copy of Lauren's book. It's called Retire Your Way. This is Retiring Today, and we thank you for watching. If you like this video, click here for more great content. Don't forget to subscribe to be connected with others just like you who are looking for engaging and entertaining retirement strategies.